It was in 2015, during the African Union Summit, when South Africa had to deal with the challenge of the International Criminal Court warrant of arrest that was issued against a sitting head of state. In 2009, then Sudanese President Omar al-Bashir was indicted by the court for atrocities committed in Darfur. Bashir denied the charges. As a state party to the Rome Statute, which established the ICC, South Africa was under a duty to arrest al-Bashir. Ahead of the AU summit, a human rights organization had threatened to go to court if Bashir was allowed to attend the AU summit. However, Pretoria had argued that Bashir was attending the AU summit and South Africa cannot dictate who should attend. The human rights body brought an application to the North Gauteng High Court to compel government to arrest Bashir. Before the court could rule, Bashir left the country.
There is the view now that we should distance ourselves from the ICC. But unfortunately, the treaty that set it up was signed not by the AU, but by individual countries.
The court later ruled that South Africa has a responsibility to cooperate with the ICC. The government later challenged that court ruling, but lost.
It is necessary in the interest of justice and the rule of law to say the following. The respondents are quite aware of the provisions of sections 1 and 2 of the Constitution, which declare that the state is founded on the supremacy of the Constitution and the rule of law. They are also aware of the constitutional enjoinder that international agreements bind the Republic, especially those that have been ratified. They are obviously bound to comply with domestic legislation and obviously the Implementation Act. They must also be aware of Section 165 of the Constitution, which reads as follows. 1, or Section 65(1). The judicial authority of the Republic is vested in the courts. 2, the courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. 3, no person or organ of state may interfere with the functioning of the courts. 4, organs of state, through legislative and other measures, must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. 5, an order or decision issued by a court binds all persons to whom and organs of state to which it applies. I close quote. At this stage, on a common sense approach, there are clear indications that the order of Sunday, 14 June 2015 was not complied with. It is for this reason that we are moved to state that a democratic state based on the rule of law cannot exist or function if the government ignores its constitutional obligations and fails to abide by court orders. A court is the guardian of justice, the cornerstone of a democratic system based on the rule of law. If the state, an organ of state or state official, does not abide by court orders, the democratic edifice will crumble stone by stone until it collapses and chaos ensues. In the context of Section 165 of the Constitution of South Africa, the Constitutional Court has also confirmed that principles of the rule of law are indispensable cornerstones of our constitutional democracy. See in this regard the case of Justice Alliance of South Africa, versus the President of the Republic of South Africa 2011, the emphasis must be on indispensable. Where the rule of law is undermined by government, it is often done gradually and surreptitiously. Where this occurs in court proceedings, the court must fearlessly address this through its judgments and not hesitate to keep the executive within the law, failing which it would not have complied with its constitutional obligations to administer justice to all persons alike without fear, favor, or prejudice.
The ANC National Conference in 2017 instructed its deployees to withdraw from the ICC.
The UN Security Council can refer the situation to the ICC because they are not state parties. And this has already happened, we see, in Sudan. Therefore, there was a referral from the UN Security Council. Sudan is not a state party to the Rome Statute. Also in Libya, there was a referral by the UN Security Council to the ICC because Libya also is not a state party. So this is what really was the thinking behind, because what the international community was completely resolute about is that we can no longer have impunity for crimes that shock the conscience of humanity. This was the thinking. It was not a political decision for them to do that. It was to ensure that there is justice whenever these serious crimes, these serious atrocities are committed. And this mandate or this power that is given to the UN Security Council should not be used as a political tool. It is just to ensure that we have accountability, we have justice in those situations. And even though there are parties that are not part of the UN Security Council, that are not part in the UN Security Council, that are not part of the ICC, the driving force behind referring should not be a political reason. It should be to ensure that there is justice in these situations.
The former Liberian president, Charles Taylor, was handed over to the ICC in 2006.
But I think the mistake that many African countries made was not to read the fine print, not to look at, for example, the anomalous position of the most powerful countries on the Security Council, the United States, Russia, and China, who, although they can ask for a Gaddafi to be indicted or an al-Bashir, they're above the law. What kind of justice is that? And why did African countries sign up to that when they knew they didn't have a permanent member on the Security Council? They didn't have a right of veto. So why did they sign up to it?
Answer that question for me if you can.
Well,
why do you think
because,
they did that?
as I say, I don't think they read the small print. I don't think also that they looked at the global power forces which would impact upon the workings of the ICC. I don't think they took that into account.
The ANC conference last year took a decision not to withdraw from the ICC. There has been criticism that the court has failed to act in an independent manner.
The questions that are being raised in respect of unevenness and double standard pointed at ICC are old questions, and are questions the ICC has never been able to respond to. That the ICC is not helping its cause, it's not building its credibility and its integrity by not being seen to be even-handed in the manner in which it deals with the issues. Now, if you look at it, President G.W. Bush of the United States and to some extent President Barack Obama all face potential cases of crimes against humanity and other violations of international law, but none of them have been investigated, none of them will be investigated, none of them will ever be hauled before this court, even though they have a case to answer in relation to international law. And they do not think they need to be tried because they say they are not signatories of the ICC. And here we are now with regards to President Putin of Russia, who has a case to answer, Russia is not a member of ICC, but the ICC has rushed to make sure that it acts on this, almost as if it's seeking approval from certain quarters of the world, almost as if it's trying to show a certain quarter of the world, showing some loyalty to one of the two sides that are now divided in this new Cold War.
Moscow has warned that arresting President Putin will be a declaration of war. Russia is not a member of the International Criminal Court. Sophie Mkwena, SABC News, Johannesburg.